Good morning, everybody. I know Scotty, I think, wished everybody a Happy New Year. I don't know whether it's too far down the track to say Happy New Year now, but Lunar Year, no, true, Lunar Year. What is it? It's the horse this year?
Horse.
Year of the horse, yes, yeah. I think today's Shrove Tuesday, and Lent starts tomorrow for all those of you who are giving up chocolate. Right, so the first part of our little presentation today arises from a question that John referred to us, and this is about demolition and whether or not you need a demolition licence when you are undertaking rectification work. Now, this, as I understand it, the reason this has arisen is because Safe Work New South Wales has suggested to the MBA, I think, that because the definition of demolition work in the Work Health and Safety Regulation 2025, so this is as of, I think, March 2025, is work to, as you see, to demolish or dismantle a structure or part of a structure that's load-bearing or otherwise related to the physical integrity of the structure. And so the suggestion is that even if you are, for example, removing a window or something similar, that you will need a demolition licence. But the definition of demolition work, as I say there, is not the whole story. Like most things, the devil's in the detail. So it's actually only licensed demolition work that needs a licence. So what is licensed demolition work? Well, it's demolition of a structure or part of a structure that's load-bearing or otherwise related to the physical integrity of the structure, but importantly, that is at least 6 metres in height. Thank you. So what's 6 metres in height? And this is where I think it gets a little bit tough. That is actually in the Act, what it says about measuring the height. So it's measured from the lowest level of the ground immediately adjacent to the base of the structure at the point at which the height is to be measured to its highest point. Now, I'm not entirely sure what that means. When they're saying the lowest level of the ground immediately adjacent to the base of the structure at the point at which the height is to be measured. Well, as you see from the definition of licensed demolition work, it's a structure or part of a structure that's load-bearing. So if it's part of a structure, you're measuring it from the base of the part of the structure that you're going to demolish, or is it, well, if it's a house, is it immediately adjacent to, for example, the window or the door or whatever that you're taking out? If you're doing a renovation on a multi-storey apartment building, or an apartment in one of those, are you measuring from the ground up to the 25th story, or is it, how do you do it? Unfortunately, as far as I can see, there's no real explanation of that measurement. But the bottom line is you've got that 6 metre qualification. So if it's not greater than 6 metres, the structure or the part of the structure that you are demolishing, you don't need a demolition licence. There are two types of demolition licence. There's a restricted one, so if it's less than 15 metres, not pre or post tensioned, doesn't involve a tower crane or a mobile crane, and doesn't involve floor propping, then you can do it with a restricted licence, or if it's greater than 15 metres, etc., and it involves any of those things, then you'll need an unrestricted licence. But that assumes you need a licence in the first place. So I don't know whether any of you guys have had Safe Work coming around and telling you need a demolition licence, or whether this is something that concerns you, or exactly how you would interpret that height issue. But that's where that aspect sits presently.
Well, one of our members was cautioned by Safe Work that they would be prosecuted if they proceeded with a demolition. Now, with that 6 metre, any single story should be fine, but with 2 story, there may be some that would be under 6 metres.
Yep.
but most would be over because people max out at the 8.5.
Yeah, and that assumes that you're measuring from the ground floor, from the ground,
Yeah.
right up to the roof.
Well, I think it'd be very complicated to try and do it the other way.
Although is the ground adjacent to the structure? So that's the question. So obviously there's an element of interpretation there. Question whether you want to take a risk or not, I suppose. So that's that.
Thank you.
Thanks, gentlemen.
Okay, so
Oi, sorry.
thank you, David. Let's enjoy our breakfast and we'll continue.
You brought spare batteries, Leo?
Big voice.
Big voice, big voice. Yes, okay. Hello again. Here I am. Now, you'll be pleased to know it's not just me today. I have with me Barbara Farhat, who's a paralegal with Bartier. Barbara's going to present the second part of this one. Now, the first part is largely a presentation that I gave to the Hunter group, but Barbara's come along and she's got a bit more to say about this particular topic, which is all about whether if you've got a claim against a builder, whether you have to give the builder the opportunity to come and rectify the defects. And it's particularly of interest, and this is the part that Barbara's going to talk about, because as a lot of you will know, Section 18BA of the Home Building Act brings into play a duty to mitigate on the part of the owner, and part of that duty to mitigate is to give the builder reasonable access to the property, either for inspection or for rectification. And Section 48MA of the Act says that the Court of the Tribunal must first look at making a rectification order, a work order as it's called, rather than giving a judgment in terms of money. So if you haven't given the owner, you haven't given the builder an opportunity to rectify, how can those provisions be complied with? So, Court of Appeal in this decision really, I think, has thrown up some questions about the interplay between the common law and the Act. And this was a matter which involved statutory warranty claims under the Act. So it was an apartment building. There were defects. The builder admitted some of the defects, but said, well, we've always said we're willing to come and rectify those items that we consider are genuine defects. But the Owners Corporation said, no, we're not going to allow you to come in because we have no confidence that you will either come and do it in a timely fashion or that you'll do it properly. There was evidence of letters between solicitors where that had been expressed. There were minutes of strata meetings where the issue of the loss of confidence in the builder and reasons for that were given, and there was also settlement discussions where an agreement had been reached in principle, but further negotiations over the course of a year to get the detail right and to reach a final agreement just never happened. So that was another reason why the Owners Corporation said these people are just stuffing us around, they're kicking the can down the road, and we have no confidence that if we did let them in to rectify, that it would actually get done. So what happened was it went off to the Supreme Court because it was a technical matter. The Supreme Court sent the technical aspects out to a referee. Referee produced a report on liability and also on quantum. The argument from the builder that the Owners Corporation was obliged to let him come in and have a crack at rectification was rejected by the referee and said it wasn't unreasonable in the circumstances for the Owners Corporation to refuse that request. As you may or may not know, if you go out to a referee and get a referee's report, in order to be enforceable, you have to go back to the court and ask the court to formally adopt the referee's report and to make orders, consequential orders. So back they went to the court. The Owners Corporation asked the court to adopt the referee's report. Needless to say, the builder said to the court, no, you ought not to adopt the referee's report for these various reasons. Justice Creais in the Supreme Court said, no, I'm with the referee, and so I'm adopting the report and entering judgment. And so the builder and the developer appealed to the Court of Appeal. Again, the argument by the builder and the developer was that the Owners Corporation had a positive obligation to give them the opportunity to rectify the defects, that it was up to the owner to show that their refusal wasn't unreasonable. As soon as the builder established that the builder was genuinely ready and willing to rectify, the onus shifted to the owner to provide the excuse as to why the builder shouldn't be able to go in and rectify. This was a tactical thing, a shifting onus, because as you would know, the plaintiff or the applicant in any matter bears the initial onus of proof to show that they have a remedy, that there's been a breach, and the breach has resulted in damage and the amount of damage. And if on the evidence it's finely balanced, it's evenly balanced, well then the appellant or the applicant or the plaintiff loses because they've got to prove. But the builder was saying, once we show that we're ready, willing and able to come and rectify, it's up to the owner then bears the burden of showing that refusing that is unreasonable. Well, the Court of Appeal said no. The Court of Appeal said at common law, there is an obligation, and what you've got to look at is in refusing to let the builder come back and rectify, is that conduct unreasonable? And remembering that it's the builder that's got to show that it's unreasonable. It's not the owner that has to show that they're acting reasonably. So, low threshold on the part of the Owners Corporation or the owner, and a difficult task usually on the part of the builder. Take some questions right at the end after Barbara has given her part of the presentation, talking about, well, where are we now when we've got that decision on the common law, but some lawyer is going to run perhaps a countervailing or an inconsistent argument under the Act. So I'll turn over to Barbara.
Thanks, David. Good morning, everyone. So now that David's taken us through the Court of Appeal's determination, I'm going to take a step back and consider this case within the statutory context, specifically sections 18BA and 48MA. So as David said, these provisions should have been in play in a case like this. They deal directly with mitigation, rectification, and the builder's opportunity to rectify defects. But interestingly, as David mentioned, Section 48MA wasn't even mentioned at all. And the court expressly stated about Section 18BA that the parties proceeded on the assumption that common law principles would apply, unaffected by the Act. So the court adopted that assumption, and that leaves us with a judgment that's deeply grounded in common law, while the statute sits quietly in the background. But let's take a look at this more closely. So Section 18BA of the HBA states that a party to the contract who suffers loss arising from the breach has a duty to mitigate their loss. It further states that the onus of establishing a failure to mitigate loss is on the party alleging that failure. And subsection 3B says that the person must not unreasonably refuse a person who is in breach of the statutory warranty such access to the residential building work concerned as that person may reasonably require for the purpose of or in connection with rectifying that breach. So we can see that the statute imports this mitigation requirement directly into the statutory warranty regime. And this is important because the case of Creais was fundamentally a statutory warranty dispute. Now, the onus provision in subsection 1B matches the common law position that we have. The common law already places the onus on the defendant to prove a failure to mitigate, and that's exactly what the Court of Appeal reaffirmed, notwithstanding that they said there was no positive duty to mitigate in the first place. Now, subsection 3B does introduce an obligation on the owner to give the builder access unless it would be reasonable to refuse. So the question arises, is that a positive duty, the duty to allow reasonable access? So there's no provision specifically casting the onus of proof on either the owner or the builder. So why didn't the court discuss Section 18BA? Well, simply because no one argued it. However, the court's treatment of mitigation aligns with subsection 1, but the court's conclusion does contradict Section 18BA subsection 3B. Now, what about Section 48MA? This section of the Home Building Act was not raised by either party or considered by the court at all. So Section 48MA provides that a court or tribunal determining a building claim involving an allegation of defective residential building work or specialist work by a party to the proceedings is to have regard to the principle that rectification of the defective work by the responsible party is the preferred outcome. So 48MA is telling us what a court should prefer as a remedy as a result of litigation, not necessarily what an owner must do before litigation. So in essence, the court must prefer rectification where appropriate. But this raises the question, does Section 48MA create an implicit expectation of access to rectify? Could Section 48MA ever influence reasonableness in mitigation? One could argue that because the Home Building Act states that rectification is the preferred outcome for court proceedings, and because mitigation requires reasonable steps to minimise loss, giving the builder access should be the default position. But 48MA doesn't create an express duty, although it might influence the assessment of what constitutes reasonable conduct. But if Section 48MA had been argued, the court may have had to consider, well, firstly, that the Home Building Act prefers rectification as the outcome for court proceedings. Secondly, that the builder was willing, ready, and able to rectify the defects. And lastly, whether the owner's loss of confidence argument was sufficient enough to overcome the statutory preference of rectification as the outcome. But the court in Creais was very clear that mitigation is governed by long-established common law principles and that those principles don't have any general requirement to offer access. So in essence, the court effectively said that not offering access may be unreasonable in some cases, but there's no legal principle that makes it mandatory. It's always a fact-based inquiry. But if Section 48MA informs the court's preference for rectification, it may vary the common law on mitigation. So where does that leave us? So Creais and the owners tells us that the builder bears the onus of proving unreasonable refusal, and refusal because of loss of confidence in the builder can actually be a reasonable excuse. But there's no positive obligation to allow rectification. And the Home Building Act tells us that under Section 18BA, owners must mitigate, but only to the standard of reasonableness. Access can be reasonably refused. And Section 48MA tells us that rectification is the preferred outcome for court proceedings. So together, what they're telling us is that owners don't have to offer access, but they should maintain objective documented reasons if they're going to refuse such access. Builders must present strong, credible evidence of readiness, willingness and capability, and the unreasonableness of refusal by an owner. Loss of confidence, as David said, if it's genuine and supported by contemporaneous documents, it will justify a refusal in providing that access. And Section 48MA gives the builder a policy argument that rectification is the preferred remedy, but not a legal obligation. So if the parties had argued that 48MA modifies the common law mitigation analysis, the court may have needed to decide whether the statute expresses a policy preference strong enough to influence what constitutes reasonable conduct by an owner. But because the parties didn't raise it, the court leaves us with a judgment that applies pure common law mitigation principles. So the key takeaway from all of this is that at least until Section 18BA, subsection 3B, so that's our access, and Section 48MA, which is the preferred outcome of court proceedings, which is rectification, are specifically considered by the Court of Appeal, the onus is placed heavily on builders to prove that an owner acted unreasonably in refusing to allow access to rectify and mitigate its loss. Thank you. I'll invite David back up if anyone has any questions. Thanks, David.
Don't run away, because if there's questions, I'm not answering.
Does anyone have any questions?
Questions? No, go.
The three tests, ready, willing and able. The dealing with owners corporations daily, the builder can often say, I'm ready, I'm willing, but fundamentally, often, in many cases, the builder's demonstrated a poor ability to conduct piecemeal rectification. How does that sit with the owners corporation? Talk about contemporaneous notice of evidence gathered. If the builder has demonstrated a failure to rectify in its methodology, so that's the ability test failed. I think that has more weight than the readiness and the willingness.
I don't know that it carries necessarily more weight. They're probably going to be part of the same pie. I suspect that if in showing that the builder's not able, or gathering evidence that shows the builder's not able, you'll probably have some evidence that he's not willing and that he's not ready to do it either, I suspect. But you've got to have all three. So if they fall down on just one, then the builder, remember the onus is on the builder won't have shown that it was unreasonable for the owners corporation to refuse. And indeed, in the Creais case, one of the pieces of evidence was that where there was some defect work that needed to be done urgently, the builder hadn't got its act together to go and do that work urgently. So that was all part of that ready, willingness and able.
How do you measure, take into account the loss of confidence that the owners corporation can have? Have you presented, is there anything to prove in order to show that?
Well, again, going back to the Creais case, there were minutes of strata meetings where they had discussed asking or agreeing to the builder's request to come back to rectify, and there was evidence that there was a discussion, that the basis of the discussion was reasonable, but they weren't silly reasons, that there were genuine reasons that were objectively held, and that was found to be sufficient. And remember, the onus again is on the builder to show that holding those opinions is unreasonable, and refusing based on those opinions is unreasonable. And there had been letters between the solicitors where the solicitors of the owners corporation had told the solicitors for the builder why the owners had lost confidence and the fact that they'd lost confidence. So that's the evidence.
There was a non-performance. The builder had said he was going to do things and they didn't materialise, as opposed to someone where the builder sent the trade to do the job. He hasn't been able to get access. He's been there 3 times and hasn't been given access. And that's documented. He's demonstrated that he's turned up but has been prevented from doing it. That's the other side of the situation. But in this particular case, the builder failed to follow through to do the work that
One of the other things that we usually run or often run where we're trying to get a money order rather than a work order, so to get over the Section 48 MA preference for a rectification order, is that the relationship between the builder and the owner has broken down. So whether they've had literally screaming matches or fights on site where maybe the builder's threatened the owner or vice versa. Been bullied, yes. Then that is a reason. That's another reason why it would be reasonable, or the other side of the coin, not unreasonable, for the owner to refuse the builder the opportunity to rectify the defects. Nick?
Was there a superintendent involved in that builder contract?
I'm not sure, Nick. I don't think that the judgment doesn't go into that level of detail.
In some building contracts, the superintendent is able to issue a direction to have works rectified, and following due process, notifications, this, that, and the other, ultimately, the superintendent can say, well, Mr. Crowley, you haven't done this. I'm getting someone else to do it at your cost to rectify the defect.
I don't think there was a superintendent on that contract.
And it was the contract was terminated, so it wasn't
Terminated.
It was terminated. Yes, yeah, that's right. And remember that at the point where the superintendent is giving a direction to rectify defects, and as you say, AS4000 is a classic. If it's not rectified, then an alternative builder can come in and do the work. That's while the contract is on foot, because you can't make a claim for statutory warranty, breach of statutory warranties, until the building contract's been terminated or the work has been completed. Because your right to damages under a building contract doesn't arise until there's been a complete breach, and there's no complete breach until the builder has actually failed because of the termination of the contract or the end of the contract
So
to
the
rectify its
defect
work.
occurred after the end of the defects liability period.
Well, the defect remained at the end of the defects liability period. Remained, or the builder refused, the builder denied that it was a defect, and the contract was terminated. So, because if the contract's not been terminated, if it's still on foot, then the builder does have the builder's work isn't discharged, it hasn't been completed, and so theoretically the builder could come back and
So the key
fix
is
it.
that the contract must be terminated.
Absolutely. Yes. Yeah. Absolutely. Any other question?
Any further questions? Okay,
Okay.
great.
Sorry, I've got one. Well, kind of two further comments. As Barbara said, until the Court of Appeal actually deals with this, what is the intersection between 18BA3 and 48MA? There is a question around, well, how does this work? And it's a bit of timing. And so it occurs to me that what you might, if you're acting for an owner who doesn't want the builder to come back to rectify and doesn't want a rectification order, wants a work order, wants a money order, is you might advise the owner that if it is reasonable for the owner to refuse the builder access, to get the work done before the end of the proceedings. You get the work done before the end of the proceedings, well, you can't make a rectification order because it's already rectified, and if the builder hasn't discharged that onus to show that not letting the builder back was unreasonable, then there's no breach of duty on the part of the owner, and you take that work order issue right out of play. Of course, whether the owner actually has the wherewithal to get the work done before the end of the proceedings is a practical consideration, but again, until the Court of Appeal
realistically,
says something else.
We're not probably in a position to advise the owner of that. We're probably in a position to say, go and see that man, he'll advise you.
Great advice, Graham. Great advice.
I like it, Graham.
Yeah. Okay. All right. Before I leave, I just had a quick comment about saying Happy New Year. Of course, we've just finished the old year, and when you come into the new year, you make New Year's resolutions. And I'm quite proud of the way that I fulfilled last year's resolutions. So here they are. you, everybody.
Thank you.